Good evening, ladies and gentlemen. Please take your positions as the event is about to commence. Before we delve into the heart of discussion, I kindly request your attention for a moment to review the rules that will govern our discussion throughout this meeting. First, be punctual. Please join the meeting on time or a few minutes early to avoid disruptions and show respect for others. Second, dress appropriately. Even though it's an online meeting, please dress appropriately to steer clear of appearing impolite and causing any discomfort to others. Third, minimize distractions. Please find a quiet, well-lit space for the meeting and minimize background noise and distractions. Fourth, participate actively, engage in the discussions, contribute your ideas, and listen attentively to others. Fifth, respect others' speaking time. Avoid interrupting others while they are speaking, and please raise your hand to use the meeting to chat if you want to speak. Second, use natural language and tone. Please maintain a natural demeanor in your language and tone and avoid using slang or inappropriate language. And last but not least, be patient and courteous. Be patient if there are any technical difficulties or if someone is having trouble speaking. Om Swastiastu. Assalamualaikum warahmatullahi wabarakatuh. Shalom, Namo Buddhaya, may peace be upon us. Good evening, ladies and gentlemen, distinguished guests and esteemed participants. It is my distinct pleasure to extend a warm welcome to each of you monthly discussion on global legal affairs, organized by the Udayana Research Center for International Law in collaboration with the Student Community for International Law. Discussion on From Theory to Practice, Implementing Countermeasures by Non-Injured State in International Law. My name is Anggita Maraneka, and I'm committed to answering that today's conversation are both enlightening and enriching. Thank you for your kind attention, and let us proceed with the utmost decorum and enthusiasm. The enforcement of international law has traditionally relied on injured states to take countermeasures. However, recent developments recognize the vital role of non-injured states in this process, and this seminar explores the legal foundations, practical applications, and challenges of this evolving concept. We will examine case studies, legal justifications, and potential obstacles to provide a comprehensive understanding of how non-injured states can effectively uphold international law. Join us as we delve to practical implication and future directions of this significant shift in this international legal enforcement. Ladies and gentlemen, it is my privilege to introduce our esteemed speaker, Ms. Putu Pratiwi, a Bachelor Law of student Udayana University, whose thesis related to the topic at hand promises to enlighten and inspire us today. Additionally, guiding our discussion with expertise, please join me in welcoming our facilitator, Mr. Gusti Ngurah Parikesit Widiatedja, SA M.Hum LL.M. Ph.D., the lecturer of Faculty of Law Udayana University, whose skillful guidance will ensure a fruitful exchange of ideas throughout this event. Let us embark on this journey together, embracing the first perspective and fostering constructive dialogue. To Mr. Parikesit, the time is yours.
Thank you so much, Anggita, for the great opening statement. It is also my pleasure, my privilege to facilitate this occasion, this special event, and we are entering the second session of international law today, monthly discussion on global legal affairs. And before continuing, I'd like to greet some of online participants through Zoom who have already joined with us. We have later will join a lecturer from International Law Department. We have also alumni from Faculty of Law Udayana University. I saw Dananjaya, I saw Ken, and we also invite a freshman or fresh student, yeah, who are taking international law course led by Bapak Maharto Yaso, who's in this event. Hopefully later more participants will join. And yes, we have Putu, Ayu, Eka, Pratiwi.
Good evening, and
we have Putu, Ayu, Eka, Pratiwi, who have successfully defend her thesis regarding implementing countermeasure by non-injured states in international law. Yeah, this topic is very interesting. Looking at the current situation in international law, because I don't know, but I'm feeling like the situation, the global situation, when the international law is supposed to create justice, to create peace and security, but the reality is, yeah, we are currently experiencing, I think, one of the most darkest situation since I think compare in the last decade or 2 decades, for example, the number of conflict among the states is increasing. Yeah, one in Russia and Ukraine, and then Israel and Palestine, and border or territorial issue like happen in South China, and then other the tendency of international law violation will create any insecurity, because and it will relate with what Eka is going to present. Yeah, for example, if a conflict involves 2 parties, and then other party, who is not actually injured, who is not directly involved in that conflict, could impose some measure. It can be classified as countermeasure. I can imagine if the conflict between Israel and Palestine, and then the Israel affiliation country will impose countermeasure. On the other hand, the Palestinian affiliation country will also impose a countermeasure, and then it will, if it's not regulated properly, it will escalate the conflict itself. And of course, we don't know. We really don't want that's happen. And this is becoming interesting because countermeasure is not really about public international law. Sometimes it relates to international trade law, international humanitarian law, and it can be done in multi-phase. So hopefully after this session, after Eka is explaining her thought, we will have fruitful discussion. But before I hand over to the Eka, let me briefly read the curriculum vitae of Putu Ayu Eka Pratiwi. Yeah, she has already graduated with praise status. Yeah, with cum laude, 3.69 GPA. Yeah, GPA is 3.69. She went to senior high school number 7, junior high school number 2 Denpasar, and during her study in law school, she joined ALSA, SCIL, and also Student Union of Faculty of Law Udayana University. She experienced many achievements, like in 2020, she was champion of SCIL International Moot Court Training. In 2022, she was the second best memorial correspondent in Indonesia national round of the Philip Jessup International Law Moot Court competition in 2022, and other achievement in relation to moot court competition nationally. And in 2023, she was in the third best applicant memorial in Indonesian national round of the Philip Jessup International Law Moot Court in Parahyangan Catholic University. Yeah. Beside her achievement, she has also experience working in some law firm or legal office in Bali, namely in HMA Law Office, and I think from October 2023 to January 2024, she worked at Sukarta and associate in Bali. Okay, I think that's the brief overview of our speaker tonight. And without further delay, I'd like to invite, I usually call her Eka, Eka to start her presentation. Okay, time and place are yours.
Thank you so much, Mr. Parikesit. Before I started, can my voice be heard clearly?
Yes, pretty clear. And also your background.
Okay. Thank you. Good evening, everyone. I extend my heartfelt gratitude to Mr. Parikesit and also the community of UNCIL in Udayana for extending this incredible opportunity to me. It's truly an honor as a speaker for today's discussion. Today's discussion is about countermeasure, has hold a special place in my heart because it was the focus of my thesis that also introduced by Mr. Parikesit in earlier. And today we delve into a topic that not only captivates me personally, but also holds immense significance in the realm of international law. So without any further ado, let's exploring together how non-interstate can implement countermeasure effectively. Okay, first, okay, I think the committee already need to the role and application of countermeasures by non-it of countermeasures, and it's really connected with the government that for national operate the domestic which have central agencies. National laws or the authority, it means that international detailed act being or state. However, we must note that there is a difference between invoking the responsibility of a state and being able to enforce the responsibility before an international court or a tribunal. Because the absent state consent make it cause there is no compulsory adjudications. Then I will bring up the case that already unfamiliar with us, the case between Nicaragua versus the United States of America, that familiar known as the Nicaragua case. This case in the 1980s illustrates how the enforcement legal system in international law is very challenges and very unique, because in this case, despite Nicaragua winning the case and the International Court of Justice giving the order to the United States of America to pay compensations, the U.S. government amendly declined the claim and refused to comply. And if this is the case, the rules of state responsibility and the law in general can be erased and completely ineffective. And also, maybe the committee can be next slide. Also, the current situations that happen in the world today, for example, in Rafah, Palestine, that also exemplifies the complexities and challenges inherent in the enforcement of international law. Even Israel actions in Rafah have been widely condemned by international community as a violation of international law. However, obtaining a binding resolutions or enforcement of responsibility has been problematic due to the lack of compulsory jurisdictions and also the political dynamic that also involved in that case. In that such case, we know now that countermeasure become a critical tool for states to respond breach of international law, because countermeasure are actions that would normally be illegal but are permitted under international law when taken in response to international wrongful act. The concept of countermeasure are intended to induce the offending state to comply with its international obligation and to make the state that responsible to make a reparation for the harm caused. Next slide, please. And the countermeasure is regulated under RCWA, that RCWA is Article Responsibility of State for International Wrongful Act. And the legal framework of countermeasure we can be found on the second chapter of part 3 in this RCWA. That the countermeasures the notion of countermeasure come across the notion as preclude under Article 22 of RCWA. In that that the wrongness of state not an international obligation to another precluded and to the of constitutional countermeasure. So, this precluded in wrong under Article 14 to 24 of on certain to govern the country, because about how the country can be recouped the resources when the country be and deal with that part, the article, the answer under Article 51st of the article responsibility. And those articles of law stands for international law, even some the principal reasons the will be still need to be this is because the International Law Committee codified that codification represent acceptable international law. Very likely that state practice will have confirmed with the in the or maybe
I'm sorry for interrupting, Eka.
sorry for the technical issues. Now, can you guys heard my voice clearly?
Pretty clear now. It's pretty clear
Okay.
now.
Sorry for the technical issues. Okay, I will continue. I also give it the case in the International Court of Justice named the Gaptiko Nagimaro case, as I could in that court. In the first place, a countermeasure must be taken to respond to a previous international wrongful act of another state and must be directed against that state. As further regulated by Article 49, Paragraph 1, the countermeasure must solely aim to induce the responsible state to fulfill its obligations. Now, we know that countermeasure is proposed to induce the state that responsible to make reparation for the injured states and to make the actions stop, and the state that the responsible can comply with international law. Okay. Next slide. Okay. We need to know about the requirements and the conditions for the use of countermeasures. Firstly, the countermeasure, the state that can invoke the countermeasure must fulfill the criteria and the requirements to use the countermeasure. First, the existence of an unlawful act. Before resorting countermeasure, the injured state or the non-injured state must ascertain that another state has committed international wrongful act, or maybe has committed a breach of international law. And secondly, the substantive requirements. These requirements regulated by Article 50 3 of RCWA, that the countermeasure must consider the scope of obligations and that must not be disturbed prohibitions of humanitarian compacts and normal requirements that regulated by Article 52 of the RCWA. Before undertaking a countermeasure, the injured state must notify the concerned state and offer negotiations. And also the countermeasure must also cease if the violation has ceased or if the dispute is under consideration by an international judicial body. And lastly, is about the time limitations that govern under Article 53 of the RCWA, that countermeasure must be temporary and reversible. The state employing the countermeasure must promptly cease its action if the offending state has fulfilled its obligations. And these conditions and requirements ensure that countermeasures are in accordance with international legal norms. So if the state that invoke the countermeasure fulfill or satisfy these requirements, the countermeasures that taken is permitted under international law. Okay, next slide. Okay, now as we know that the countermeasure under RCWA only tell us that is implicitly the only injured state that can invoke the countermeasure. However, other states beside the injured state may also have the right to enforce responsibility under the condition set out in Article 48 of the RCWA. These states have a rightful interest in ensuring that the responsible state respect its international obligation, especially when those obligations protect collective interests. This notably the case when the international wrongful act is continuing and consists of a serious breach of an erga omnes obligation under peremptory norms of general international law. Next slide. And the injured state, now we know that why non-injured state should be entitled to resort countermeasure. The injured state is entitled to protect its right by resorting the countermeasure. But in such a situations where all other states are entitled to resort to countermeasure to add a pressure and responsible state and bring about an end to the serious breach sooner. Of course, a meta principle such as situation could justify by sanctions by the United Nations Security Council, but what if the Security Council use
Hello, Eka, are you still there? It seems that you are disappear from the screen.
sorry everyone. Now maybe I have a connection issue here. Now can you hear my voice?
Yeah, it is
Okay, I
clear.
will. Okay, sorry for technical issues again. Okay, I will continuing. Okay, as we know that if only injured state that can invoke the countermeasures, how if the situations when the UN Security Council use their veto to draft resolution to condemn the violations or breach the international obligation that the state do. And if genocide or ethnic is blocked because they use their threat, must the rest of the world merely pay the lip service to the prohibition of genocides and human rights and then do nothing, standing and by watching? On the face of it, it does make sense, allow non-injured state to put pressure with non-forcible countermeasures on the state responsible for the most serious breach. Okay, now in the next slide, we begin again about the rules of countermeasure by non-injured state under the RCWA. Article 54 of the RCWA is governed about the countermeasure that by non-injured state. But this article is very controversial to the international commissions, and this articles one of the primary controversial in this article is because whether a non-injured state has the legal authority to invoke the countermeasure. Article 54 does not explicitly address these issues because in their making process of RCWA, there are some many controversial on the international commission's members, and this leading to varying interpretation among legal scholars and practitioners in the present. And to answer and to know about does the Article 54 can prohibit non-injured state to invoke countermeasures, I go to reviewing the process of formulating countermeasure by non-injured state within the RCWA through the dropout preparatoire or the documents that involve examining discussions and formulations conducted by international commissions from 1963 until the final drafting. I found after reviewing the process of the RCWA, the non-injured states are permitted to employ countermeasure as stipulated under Article 48, paragraph 1A and B, that referencing obligation erga omnes. And also Article 48, paragraph 2, grants the right to states entitled to aim responsibility under the responsibility under paragraph 1 to demand cessations of the breach and assurance to reparations. And this article also asserts that the requirements for claiming responsibility by the injured state apply equally to other states entitled to claim responsibility in accordance with Article 48, paragraph 3. Regarding Article 54 of the RCWA, it is argued that this provision fundamentally does not diminish the right of non-injured states to take lawful measures against the responsible cessations of the breach and reparation for the injured state interests. The ILC employees use the phrase lawful measures instead of countermeasures. It deliberately allows for ambiguity and broader interpretations. And despite the drafting process initially aiming to incorporate the use of countermeasure as proposed by James Crawford, this language was broadened to include rather array of measures. However, in the present, 54 normally used by state to invoke countermeasures to invoke countermeasure into state responsible. Okay, next slide. Okay, when the International Law Commission codified the rules of countermeasures by non-major states, it drew upon state practice that had developed over time. This practice reflects the principle and norms of customary which are fundamental sources of international law according to Article 38(1)(b) of the Statute of the International. This article identifies customary international law as an evidence of general practice accepted. For instance, the first case, that sanctions against South Africa. In 1990, several countries implemented measures against South Africa that exceeded the sanctions imposed by the United Nations Security Council. These countries took additional steps to exert pressure on South African government to end its apartheid regime. Measures included the trade restrictions, ban on new investment, and the severance financial ties. And these actions were taken independently by states such as United States, the United Kingdom, and various European nations, reflecting a collective stance against apartheid even before the international community reached a consensus through the UNAC. And the second case is raising of Iraqi assets and trade embargoes in 1990. This case is about following Iraq's invasion of Kuwait in 1990, that the United States and European Union member states froze Iraq assets and imposed trade embargoes prior to the extensive sanctions later imposed by the UNIC. And this proactive stance aimed to weaken Iraq economically and pressure it into withdrawing from Kuwait. And this measure demonstrates how non-injured states can take independent actions to uphold international peace and security in anticipation of broader international sanctions. And for the current situations also, that the sanctions imposed by United States of America against Russia, the United States and also the European Union took a series of measures against Russia following its alleged involvement in the crisis in Ukraine and the annexations of Crimea in 2014. And these measures include asset freeze, travel bans, and restrictions on financial transactions with Russian entities. These sanctions were aimed at deterring further Russian aggressions and supporting Ukraine's sovereignty and territorial integrity. And these actions were taken independently of the UNAC, demonstrating a unified Western response to perceived violation of international law. And this case illustrates how non-injured states can play a proactive role in the international legal system by implementing countermeasures to address breach of global order. Okay, the measures taken often aim to first exert economic and diplomatic pressures. The sanctions and asset freeze are designed to create economic difficulties and diplomatic isolation for the target state that breach obligation of international law, and encouraging compliance with international norms. And secondly, these sanctions aim to support human rights and humanitarian principles, because many countermeasures aim to halt human rights abuses and protect civilians populations, as seen on the case that I stated earlier from South Africa and Russia. And lastly, this countermeasure aim to uphold international peace and security. By acting independently, non-injured state can address urgent threat to peace and security, as in the case of Iraq and Ukraine, sometimes anticipating or complementing UNAC actions. And this action reflects a commitment to upholding international law norms, even if the absence of direct injuries to the state, implementing to the countermeasures. And also to underscoring the principle of collective responsibility in international community. Next slide. So now we need to discuss more about the implications of countermeasure in international enforcement. When the non-injured state or maybe injured state invoke the countermeasure to the target state, it can be impact to the international law enforcement. First is about the consequence of human rights that can be raised if the countermeasure taken by state is disproportionate. And secondly, the importance of ensuring compliance with international human rights standards under UDHR, ICCPR, and ICECPR. And secondly, the implications for international relation stability. Threat posed by the countermeasure can be threat posed by the domino effect to international relation stability and increased likelihood of external intervention or global conflict. And lastly, even though it can be impact of negative, but also it can be positive impact also. The countermeasure also can be alternative actions in response to failure of international law enforcement mechanism. When international law enforcement mechanism fail to effectively address violations of international law, the non-injured state often can be compelled to take the actions. Okay, I think that's all for me to telling about the legal notions of countermeasure by non-injured state. I bring back to the Mr. Parikesit to more discuss to the participations about the concept of countermeasure by non-injured state. Thank you.
Okay. Thank you so much, Eka, for the nice and inspiring presentation. I think your presentation now will give more than your thesis defines, right? Because I recognize some explanation you can explain in more detail, in clearer compared to your thesis examination last time. Yeah, you include more cases, more current cases, and then some explanation about how the countermeasure are regulated under existing international law, yeah, especially under article on responsibility state of internationally wrongful act, or RCWA. Okay, what I can summarize from your presentation is that, yeah, the countermeasure is actually regulated under international law, and it countermeasure by injured state is permitted with some condition. And Article 54 explain, although it doesn't expressly stated about non-injured state, but the language, measure taken by state other than uninjured state mean that, if some particular country feel that their interests, their national interests, although they are not involved in the direct conflict, then they can impose like a measure that can be classified as a countermeasure. And I think this is a good starting point to discuss, to reflect what has been regulated under current international law and what is actually happening in the current circumstances. And before opening discussion, I'd like to greet some participants who have already joined. I have been informed that Bapak Putra Ariana already joined. Good evening, Bapak Putra. Thanks for joining. And also some alumni from Faculty of Law Udayana have already joined, like Bapak Aldo, Bapak Aldo Geraldi, the previous
semester.
Long time no see Bapak Aldo, so we call it was, I don't remember exactly, but it's around 2010, right? When you serve as a SAL leader. And also we have also Dananjaya and Ken who have already joined, and it will create any connection between the lecturer, between the alumni, between the just graduate student, of 4-year student, 3-year student, and then also the new student also join today. And if you don't mind, Eka, would you like to share the slide to the other participants? So it's like this discussion is like another important class for international law student. So if you don't mind, then you can share the slide presentation to the other audience. And for those who want the slide presentation, then you can directly contact either Eka or Farah. Okay, let's begin. So I'd like to invite first for Danan, to give like a brief overview or brief statement about the international law issue in general, and if of course, I open that you can comment with what Eka already present. Are you still there?
Yeah, I'm still here, but thank you very much. I'm so sorry I cannot turn on my camera because there's some situation that I need to adjust to join this Zoom meeting. First of all, I'd like to thank Parikesit for hosting this very beautiful seminar. So we can gather here, as you have already mentioned, the alumni, students, lecturer are gathering here to discuss about international law issues. Second of all, I would like to thank Eka for the amazing presentation. It was very nice presentation and very detailed on the issue that we're talking on, the non-injured state countermeasures. So for the context, that issue was brought in JESAP 2023. It was one of the problems that we discussed for the competition. And it was giving the solution toward the problem of Ukraine and Russia conflict where the European Union gave sanction to Russia because of the invasion. Very nice because it not only extends to that problem, but also how we're talking about genocide and crimes against humanity, which are the collective responsibility of international community. However, there's one thing that I would like to ask because this is very crucial when it comes to law. We cannot judge that something is done before there is a court decision, for example. So when we're talking about genocide or crimes against humanity, I think it would be it has a very big burden for us to prove that that action is happening right now before giving the issue to the International Criminal Court, for example, or International Court of Justice to decide whether that action happens. But if the states, especially non-injured state, impose countermeasures before the court even give the decision, would that be okay in international law? Or is there any criteria or parameters that we need to follow just to make sure that the legality of that countermeasure? I think overall, the discussion is very engaging and very nice, but we need to enlighten on that issue so the law characteristic would not be forgotten in this discussion. Thank you very much.
Thank you so much, Danan, for nice and also critical and important analysis. Yeah. And for this information, Danan can be considered as a coach for many law court competition, right? so he has trained many law school students to be able to compete in some moot court competition, not just moot court, I think. And yeah, we are lucky that Danan still here and then still want to interact and give his knowledge to the younger generation of law faculty of Udayana University. And definitely is going to be the next speaker that not just in this event but also in the any academic event across Udayana University. Okay, thank you once again, Danan. And I also want to greet Ken. Are you still there, Ken? Would you like to give some thoughts about international law issues or countermeasure issues? Ken, are you still there? Or yeah, I will call you later. I will give chance maybe in the before the closing statement. Okay. Thanks for your patience and cooperation for all participants. It's time to me to open the discussion, and this is relaxing and friendly gathering. Yeah, don't feel under pressure. Even if you can express in English, you can still express in Bahasa Indonesia. Yeah, for those who want to raise a question. So this is not under pressure meeting. So I'd like to invite some participants. If you have a question, just raise your hand. Oh, there are already two, Audrey and Laetitia. Maybe based on the letters, I will choose Audrey. Okay.
Okay. Excuse me. Can I be heard clearly?
Yeah, it's clear.
Okay.
Yeah.
First of all, I would like to apologize in advance about the camera I am unable to turn it on right now, but I am very intrigued with Kakak Eka. Something I wanted to ask is, being a relatively new person in law, especially international law, I would like to ask regarding how the actual concrete examples of this per se act against genocide and things like that. Because one thing that I've noticed being Gen Z is that social media shows a lot of how people are trying to fight for it because they know that the government does not really care. We actually talked about this in Parikesit's class about how nations have political correlations to each other, obviously, and they might not be willing to sacrifice this connection that they have because obviously it gives them benefits economically and politically. So I would like to ask how, one, we as, people with per se no power in this dynamic can actually do something, and two, how does that actually show that people can still care about international law without having to be in positions of power? Thank you very much.
Okay. Thank you, Audrey. Would you like to answer directly, Eka? Yeah. Yeah.
Okay, so I will answer for the first questions by Kadanan. Is about what is parameter for the non-interstate info countermeasures before the International Court of Justice or maybe tribunal giving the decisions about that conflict. So the first, as I stated earlier in my presentations, there are some of requirements um, that also imply to the non-interstate when they invoke the countermeasures. First, we need a must know that the breach the international obligations happens, and the second, um, the the state that invoke the countermeasures must not violate the international law, such as not breach the sovereignty of the states. For example, if, for example, the United States of America imposed the sanctions, the restriction sanctions to Russia uh, uh, through their through their domestic legal systems, that that's a sanction. It's not uh, further uh, apply apply beyond their jurisdictions. So that sanctions only in their jurisdiction's territory. And second, and thirdly, it's the countermeasure cannot breach the human rights law as set out in the ICCACR and ICCPR. And the countermeasures by state, by non-interstate, also can be justified through the Article 21 of of trade world organizations um, treaties, the GATT treaties, that can permit the state to their trade if that situations to respect international law conflicts or breach international law obligations. And lastly, the important requirement to non-interstate invoke the countermeasure is the countermeasure must be proportionate. The proportionate it can the proportionate the countermeasures not um not violate the rules of international law in general, and also um the requirements like the countermeasures must be seen already cease their actions. So if that requirements satisfied, the state not violate the sovereignty of state, and it's not violate the international human rights law and international law in general, and also the countermeasure is proportionate, the countermeasure invoked by non-injured state can be permitted and can be justified. I think that's all for the questions by Kadanan. I hope it can be answered. And for the second questions, how can we do to react about the genocides actions by state as a persons like without any powers? I think the thing that we can do is being as a law student, we can help to make publications to research about what happened in that case, and we can giving the opinions, and therefore it can be that can help bring a knowledge that that case is very important to know, and also as a social media is very wide now and is very important now. I think we can express our opinions and speak up, also speak up for, or maybe we can donations or giving permissions to that case. So I think as a regular person, the only thing that we can do is, especially as a law student, we can write the paper to research about that case. Therefore, we can bring other person's knowledge about that case, and also we can do also participate to express our voice to the words that the case is very important to know. I think that's all for me, Bapak.
Okay, Eka. Thanks for a great answer. And my apology to Danan because I'm not mentioning your question. And then thanks for Eka for your reminder. Yeah, it is quite debatable whether when we want to make any great justification to impose countermeasure, do I need to wait for the international court decision before conducting some measure, or do I can unilaterally impose countermeasure without any legal justification? Yeah. And this is also reflect to the current situation when ICC want to call the Prime Minister of Israel and then the leader from the Hamas, and then definitely they don't want to be called. They just collect support from their affiliation to ignore, to assume that ICC has no legitimate measure to call the Prime Minister. So once this practice is not is not managed properly in the future, many countries will neglect the existence of international criminal court. So, this is still a great issue to be discussed, and it will definitely affect how the international law should be enforced. And for the second question from Audrey, for the actual example for genocide, for example, or act against genocide, if you know the story, the past story when international law had not been exist, we know the story of genocide in Mussolini, Hitler era, and this has become the reason why ICCPR was issued, why Geneva Convention was issued, because at the time, to respond the gross violation of human rights, then some state then create international convention. And I think my understanding is if state has no power, how can they impose countermeasure? I think, if I'm not mistaken, this is also a tricky question. If a small country doesn't have any influence in political and economic, for example, and do they still have any power to impose countermeasure? In theory, there is a rule about that, but in practice, it is still difficult for small country to impose countermeasure. I have example case in relation to international trade law. If you type gambling cases between US and Antigua, Antigua case versus US under WTO gambling cases, the panel and then the appellate body, decide that US violated WTO rule because discriminatory measure in prohibiting gambling, online gambling. Online gambling has been exist for a decade, and US want to ban online gambling that based on Antigua. Antigua is tiny. It's not that small. It's tiny country in South or in America continent. And but US didn't comply fully with the WTO decision, and Antigua actually has a right to impose countermeasure. But the reality, because the situation and then the condition of Antigua, which is a small country, it wasn't able to impose that kind of measure. So that's a story. I just remember that story because there was a story when a small country can beat big country under the WTO, but when the big country didn't to impose the countermeasure, then yeah, because the situation and then the condition, that country wasn't able to, to impose the measure. Okay. Do you have any more comment, Eka?
No, thank you, Mr. President.
And how about Audrey? Before giving to other students or participants, do you want to clarify or to discuss more? Audrey, are you still there?
Yes, sir. Thank you for the answer. It was very
Oh.
satisfactory. Thank you juga, Kak Eka.
And for the next one, I saw Laetitia. Yeah. Laetitia, where are you? You might start now.
Okay, thank you so much, Parikesit, and also thank you, Kak Eka, for the very brilliant presentation. My name is Leticia, or you can also call me Leia. I'm so sorry if my voice is quite sore. If I need to maybe repeat my question, maybe Parikesit and Kak Eka can ask me to repeat it again. Okay, so my question is that okay, so my question is actually at start it was the same as what Kadanan has questioned, whether there must be a judgment first of a state having conducted a violation before any state can conduct a countermeasure. However, as Kak Eka has also answered it very clearly, I will only just add to this add to that question. So if we see the current case, the case on what happened to Palestine and very recently on Rafah, which previously Kak Eka has also mentioned in the presentation, I wonder if that gap in international law on the controversy on whether there must be a judgment first before conducting a countermeasure might be one of the reason on why this problem still exists, because personally I think it is quite sad that this case has been going on for so long, the case in Palestine and maybe also the war on Russia and Ukraine too. Do you personally if it is one of the reason on the thing, the genocide on Palestine and Rafah, do you personally think that this is a gap hole in international law? And probably because it's also a matter of erga omnes, which definitely will be something urgent and serious. Is this also one of your concern on why you are writing your thesis on this? And lastly, are there any case in international law where a state individually or states collectively has conducted a countermeasure before a judgment has been adopted yet? So that's my question. Thank you so much.
Yes, you may respond, Eka. It's still on mute.
Okay. Sorry. Yeah. This is one of my inspirations when I written my thesis, because I see the international law enforcement is very unique, because when state that is not have a consensus um to make a conflict resolutions to stop the conflicts. It's very unique because this work must have the same stage, the same what I mean is the states, all the state in the world have a same thought that, for example, that happens in Palestine, that the Palestine must have a right to their territory, but international law enforcement cannot do that because there is a organization named is the United Nations that have a body, UNEC. The state only can propose the draft resolution to stop Israel actions through their body, through that body. Therefore, however, the UNEC have a power to veto, and it is very clear. It passes is really paradox because it cannot be stopped. It cannot be stopped because the power of the state, the P5, the draft resolution to stop that action by Israel's. And yeah, I think even though this countermeasure is one of tools that can state use to help the injured state to stop the breach of the responsible state. If the the international community in general is not organized and not together impose the countermeasure. For me, it's like if only one state that impose the countermeasure, it cannot be effective because we don't know that the state that have a power, have a same power to stop that actions actions by the responsible states. And yeah, I think this even though there is an option that countermeasures, again, it is an international law. The approach is coordinative. Every state have a sovereignty, and every state can be judge itself. Therefore, it's very hard to stop one of states that breach the international obligations, because we need every state is in one position. Therefore, yeah, I think the countermeasures is only the alternative way, is only options, but against this mechanism of international law enforcement against by the UNACs, because all the state has agreed under the United Nations charters that giving the UNEC power to make to stop the breach of international obligations under Article 25 of the the United Nations Charter. And yeah, I think that is the key. If in this prison can amend the United Nations charters or remove the UNEC veto, I think it can be different. I think it will be more effective in international enforcement to imply. I think That's all for me. Maybe Pak Parikesit can be add some suggestions to answer, or maybe answers the questions.
Thanks, Eka, for the answer. And yeah, maybe I just add some point. Yeah, it's pretty good. And yeah, back to the nature of international law. Eka said that is coordinative. That's right, because if we can compare with national law, for example, within national law, everything clearer. Who is drafting the law, which is the legislative? Who is the implementing the law, which is executive? And then who is enforcing the law? That's judicative, or we can refer to the trias. Yeah, we call it trias politica from Montesquieu. Everything is divided based on rule. And if someone just break the rule, they will know the consequences, and then there will be independent body to enforce, to give punishment. But in international law, the situation is quite different. International law actually based on the consensus. That's why when we refer to the theory of Hans Kelsen, for example, the nature of international laws bind by pacta sunt servanda, for example, or by the common consent theory. Yeah, all state, all country agree to build international law, but behind the agreement, behind the consensus, every agreement, every consensus contain any, because each country, they will bring their national interest, and then its national interest never be the same in each country. And what was happening is that they did a negotiation. Negotiation mean that compromise. They have to compromise. They have to give up some national interest. Yeah, and then because international law built from the compromise, from the political consensus, particularly, then you know why, for example, the member of Security Council under United Nations divided into fixed, non-fixed, permanent, non-permanent member. Why some particular country have veto right and others didn't. It is based on the compromise. And that's the drawback. I can say this is the drawback of the international law. And then it will impact the implementation and the enforcement, because the international law itself is built from the political compromise. And the political factors under international law is bigger compared to national law. If it's national law, there is also political compromise, political negotiation, but usually they have a base point. They have like a minimum benchmark under its constitution. Every state must have like a constitution, either written or unwritten, and then every negotiation, every political compromise should be based from the constitution. there is a rule, there is a minimum benchmark compared to international law. Yeah. For example, why United Nations Charter consists several countries, and usually they country, because the reason why international law exists cannot be separated from the political negotiation or political compromise behind them. So why for example, why the US always silent when Israel, for example, conduct any indication of violation? And why, for example, US so aggressive when Russia try to invade some part in Ukraine, or US seem to be aggressive when China, if you ever hear that China product in US have been discriminately filter, like what you call it, the phone product from China that cannot be enter US market. That's a kind of situation, the dynamic under international law that color the current situation. Do you have any follow-up question, Laetitia?
A bit, Pak. Thank you. Previously, thank you for the answer, Kak Eka and Kak Parikesit. I have a bit of a follow-up question, a bit more like a confirmation, actually. So, that means that in international law itself, until now, there has been no countermeasure that a state or some states did before there was a judgment or maybe a resolution from UN. Maybe the Nicaragua case that Kaika mentioned earlier, was that a countermeasure or is it something else?
Yeah, you may respond, Ka. Yeah, and it's still unmute.
And we talk the countermeasure. It, the countermeasure used for Nicaragua case. The court that uh, uh,
It's still on and off. Maybe could you repeat? It's still on and off. It's not stable. Could you repeat again, Eka? Yeah. Could you try to speak?
is it my voice clear now, Mr.
Yeah, it's better.
Okay, so in Nicaragua, Nicaragua can the U.S. The U.S. embargo and withdrawal of aid amounted to interventions as were coercive. When you use the Nicaragua case, for example, the case of countermeasure is not is not example of the countermeasures directly, but we can use the case of Nicaragua to know that the countermeasure that used by state is intervention or not. So it can be countermeasure when we use the, because in that case, actions of the U.S. go withdrawal aid. And we also when we do state that use the as when I answer that when the state use to responsible by the international law, the sanction or maybe the state use the economic sanctions. That sanctions cannot violate the sovereignty of that state. Therefore, some criteria to know is that the sanctions is violate the sovereignty of the state or not. We can use the Nicaragua case for know the standard that the sanctions is not violate the duty of non-intervention, for example. So the Nicaragua case is not countermeasures examples, but I can giving you the another example that a state use the countermeasures without the UNAC resolutions, such as the and when in now try to not giving the military aid to the Israel and also implied to the Russia, Ukraine that U.S., the Canada, the United Kingdom also impose the sanctions without the UNAC resolutions. Yeah, I think that's all for my answer for Leah questions. Hopefully, it can be answer the questions. Maybe Parikesit or maybe other audience or participant have arguments or answers the Leah questions. I think it will be good because it's discussions, so everyone have a right to speak up. Is it right, Mr. Parikesit?
Yeah, that's right. It has been regulated under Article 28 of our Constitution. Everyone can speak, freely speak, in this event. But other than what Eka has said, I have like a trend when the country, actually impose a countermeasure, but they don't want that the measure classified as countermeasure because some reasons. For example, like this, the government of Indonesia never expressively said that Indonesia doesn't agree or fight against what Israel did in Rafah, right? There is no formal statement about that. But there is a movement. There is a movement from NGO, from influencer, to not buy any product that made from Israel. and the government secretly facilitated. Secretly facilitated. But of course, Indonesia doesn't want to be in the position to support Palestine because China and also with happen if you saw some YouTube content creator, there's sometime campaign that okay, this is the list of the product from Israel, and then amazingly the product is very popular. Yeah, it's like KFC, Burger King, and etc. Yeah, and if you support for the Palestinian, don't buy this kind of product. But the government doesn't want to be in the position to expressively support the movement, but facilitate, just facilitate, and that's quite interesting. And also because we also had any experience about the embargo. Maybe Eka has said as well about the military embargo, because some military equipment for Indonesian forces, yeah, had been blocked for almost 10 years. That's why the situation of Indonesian Army is a bit late. Yeah, the advancement, the technology a bit late compared to the neighborhood country like Singapore and Malaysia, because the embargo that was imposed. So this is pretty interesting, and this is also reflect how the dynamic international law is always happening, and it become from this presentation, I hope it will inspire and it will also open a new opportunity to all participants who are attending now. To this is always a novelty issue that need to be deeply observed by you. There is open opportunity to make a propose a thesis, or script, we call it scripture. There is always a new issue to be discussed, to be explored on international law concern. I think that's all my brief comment. How about you, Laetitia?
Yes, thank you so much, Parikesit and Eka. It was very clear. Now I know that boycott does not need, countermeasure does not need to be always explicit. It can be implicit. I think that's what I also get. So thank you very much. It is very understandable.
Okay, I will open for, I think we still have around 15 minutes, maybe one more questions, the final question, or maybe if you just want to add new information or to share information, it is also very fine. And again, don't feel under pressure in this friendly gathering. Okay, who would like to be the third? Okay, would like to be the third? Okay. If there is no more questions, I'd like to say thank you for Eka for nice and fruitful presentation. Your final thesis defense actually, and yeah, this also happened in the previous meeting. Yeah, when Tata also present about the cyber warfare, and then she present well, even better than final defense. Yeah, maybe because this situation there is no pressure, there is no fresh confidence or sidang. So it feel when students are in the lack situation, and then there is no pressure, then usually they can express their idea smoothly and better. Once again, thank you, Eka, and thank you for all participants who are attending on this special night. Hopefully, this discussion will give you any insight, not just about the issue about international law, particularly about countermeasure, but you can also see the content of final thesis student, especially who take specialization in international law and international business law. So there will be no what I want to call no worry, no like overreact or overthinking about making a good final thesis. Because if you have supervision, intensive and continuous supervision, everything is under control, and in time can be handled in timely manner. And also for organizing committee, thanks for making this discussion possible, and we will continue this discussion next month with other students from Faculty of Law Udayana University. I think Ayu Sri Undari will be the next presenter to express her idea. Okay, that's all my brief comment, and my apology if there is inconvenience happening during this event. Now I will hand over the event to Anggita. Thank you.
Thank you so much to Mr. Parikesit and Ms. Ayu Eka Pratiwi for an amazing discussion session. Your dedication to facilitating meaningful dialogue is greatly appreciated. Ladies and gentlemen and distinguished participants, we invite you to fill out the attendance link as you may access the certificate of appreciation by the end of the forum. Our team will send the link through the chat box. As we draw to a close, I extend my deepest gratitude to each participant for their valuable contributions to today's discussions. On behalf of the organizing team, thank you for your active participation, and we look forward to welcoming you to future events. Until our next online encounter, stay safe and connected. Om Santi 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 Om. Wassalamualaikum warahmatullahi wabarakatuh. Shalom, Namo Buddhaya, may peace be upon us.